Shweta, you are inaudible.
Okay, let's begin.
You're better now, yes.
Yeah.
Good afternoon, everyone. Firstly, I would like to congratulate the teams for making it to the quarterfinals of the third national virtual moot court competition being conducted by Thomas George and Associates. My name is Shweta Surendra, legal intern of Thomas George and Associates, and I will be your court master for today. We are pleased to have Mr. Chetan Priyadarshi and Sharanya Kundu ma'am as our judges for today. Mr. Chetan Priyadarshi enjoys specializations in company law and insolvency litigation domain with a specific focus on recovery litigations and builder consumer disputes. Sir has spearheaded multiple litigations before the NCLT and the NCLAT and has earned a considerable repute as an effective practitioner in this domain. A Pune University graduate, Sir has an illustrious past with senior Supreme Court lawyers where he handled general commercial litigations and appended disputes. Ms. Sharanya is a transactional lawyer and is currently working as a senior associate with Samvad Partners, Bangalore. She specializes in PEVC, M&A, and general corporate matters. She graduated from ILS Law College, Pune in the year 2015. I will now proceed to explain the time division granted to each counsel in a single team. Each team is allocated 30 minutes to present their case. Each speaker will be given 15 minutes unless indicated otherwise by the team. Placards indicating time will be shown 3 minutes prior to the lapse of time and finally once the time has lapsed. 30 seconds each will be allocated for rebuttals and surrebuttals. We have team 21 representing the petitioners and team 4 representing the respondents. With the permission of our learned judges, we shall commence the quarterfinal round of the third virtual national moot court competition.
Please start. One thing for the speakers, we don't expect any niceties. You don't need to ask permissions before you start presenting. Just start off. Okay? Get to the point on immediate basis.
Petitioners Counsel, could you specify your time breakup, please?
It is equal to 50-50. I will speak for 15 minutes and he will speak for 15 minutes.
Okay, you may proceed now. Thank you.
Can I start?
Yes, please.
With your lordship permission, the council would like to begin with the council appearing on the behalf of the petitioner in this instant case. The petitioner council will be specifically dealing with the issues that whether or not the government is justified in taxing the digital currency, digital assets, and NFT, etc., which are not legalized, and whether or not Section 115 Clause BBH of the Income Tax Act is violative of a Constitution of Parliament. The first issue will be dealt by me, and my co-counsel will be dealing with the second issue. With your lordship permissions, the council would like to proceed with the facts of the case.
Please
The Republic of Parliament, which is democratic, secular, socialist nation. In the recent times, it is gained popularity in the international nations organization for boosting its economy. And during the COVID pandemic, there was a huge rise in the digital assets and their transactions. And in the absence of an appropriate legal framework regarding to the virtual digital assets, digital currency, NFTs, which is also known as non-fungible tokens, and the government implemented a new tax regime aimed at taxing gains or income from the virtual digital assets at 30%. The citizens of the nation were perplexed and they filed a special leave petition. If your lordship is well versed with the facts of the cases, then council would like to proceed with the argument advance.
Please go ahead.
Treating cryptocurrency with other DLT under umbrella of a virtual digital asset is not justified, and imposing tax is a violation of law. In relevant finance bill, the Ministry of Finance made attempts to define the virtual assets or currency and consolidated all the attributes of a distributed ledger technology, which is known as DLT, and a blockchain like a cryptocurrency and NFTs into the definition of virtual digital assets rather than defining them separately. This definition is vague and lacks the clarity as a difference between the virtual currency and virtual digital assets, as they have different features and they cannot be treated equally for the taxation. Cryptocurrencies not being an Indian or a foreign currency, the proposed digital rupee will be seemingly as exempted as a result, but any information or a code number or a token not being an Indian currency or a foreign currency generated through the cryptographic means or otherwise by whatever name called, providing a digital representation of a value, exchange with or without consideration, with the promise or representation of having a inherent value or functions as a store of a unit or a unit of an account, including its use in any financial transaction or investment, but not limited to investment scheme, can be transferred, stored, traded economically as the NFT similar tokens are central government may notify such other digital assets the central government.
Council. You are reading through it. Explain, present it in a manner that is easy for us. For us, it's the first time we are dealing with tokens. And I don't want to get into the inherent issue of what a token is, what is an NFT, or what is cryptocurrency. But instead of reading, tell me what you have understood of the law and how is this law against your fundamental right. You are filing a writ petition, right? You're not filed an SLP. So as per the writ, this should be against your fundamental right. Do not read through your notes. Tell me what you have understood.
Okay.
And I do not want to get into the details of what is the differentiation between a NFT, a cryptocurrency. For me, everything is a VDA. So tell me how this section is violative of the Constitution of India.
How it is violative of a constitution in India. This is the issue which we'll be dealing with, which will the co-council will
By
deal
speaker number 2.
I will deal with the how government is not justified with taxing the media.
Yes.
First of all, the central government has to notify the NFTs, tokens, or other virtual digital assets to which the provisions of income tax which apply. While it may therefore argue that no NFTs are presently covered by the new tax regime, there is a possibility that the tax authority will elect to tax NFTs under the cryptocurrency heads, as the definition includes the tokens and may be considered as a wide enough to include the NFTs.
So do you mean to say, Council, that it has to first be legalized to tax it?
It should cover under definition. It is not defined.
So anything which is illegal cannot be taxed is what you're saying in submission.
No, Your Lordship, that is not my submission, because there are many things in like Republic of Parliament which are not legal, but still they are taxed. This is not about legal and illegal. This is all about justification, whether the government is justified in taxing the crypto.
That's a policy decision of the government. Why should the court intervene in that matter?
If the taxation system is arbitrarily imposing on the citizens of the Republic of Parliament, then government at least should be justified for
Continue.
implementing a new tax regime. There are difficulties may arise in determining the taxpayer's taxable income or gains from the receipt of a transfer of the virtual digital assets, where a VDA is received without consideration for a consideration lower than the fair market value. Difficulties may arise in determining the person's taxable income in respect of asset. Cryptocurrencies and NFTs are generally extremely volatile and valuations fluctuating on a regular basis. Therefore, it may be difficult to pinpoint the fair market value of the asset. Then where the cryptocurrencies purchased on a crypto exchange.
Sorry, am I audible?
Yes.
Yes, yeah.
Council, how is the relevance of a valuation important in your argument for justification for the government in legalizing this?
Your Lordship, I will answer this question.
Sure.
When we receive VDA, which is a virtual digital assets, which is lower than fair market value, because the prices of these all assets are fluctuating within the second. So whenever we receive lower than the fair market value, and then it is difficult to determine the actual income.
There are shares also, right, which sometimes have something under fair market value. Sometimes, okay, not all the times. If it goes to a foreign country, then we will have to do a valuation of that. But how, I mean, it's again legal, right? It's justified. We still have a lot of transactions in that. So now, how is a lower valuation of a virtual currency comes into this argument? I'm trying to understand your thought process here, counsel.
So first, I will answer your question, Your Lordship. For example, if someone is buying the virtual digital assets through, and like in India, we have a different kinds of broker. For example, the Zerodha and Grow More and app. So their commission rate is different for each app. So for example, the Zerodha charges 10% for a short term and 15% for a long term. So when we buy and such a virtual digital assets on a international level, there are different types of price for a single virtual digital asset. For example, if you are buying the cryptocurrency, then that crypto is available on different prices levels.
Also, like we're again going into the technicalities of the crypto, right? Again, the whole point is why it is unconstitutional to have legalized this, right? So maybe we can go ahead to those arguments.
Yes, with your lordship permission, I will go ahead with.
Sure.
The problems may also arise when a person is liable to tax on a transfer of the VDA. The only deduction permitted on the income earned from the transfer of a VDA is the cost of acquisition, where the virtual digital asset is purchased and sold for an identified amount in a Indian rupees or a foreign currency. The income and the cost of acquisition are easily identifiable. However, if a VDA is acquired using or sold in an exchange for another VDA, for example, the NFT is purchased being using Bitcoin, the cost of acquisition and or a consideration for the side of VDA may be difficult to ascertain as a specific Indian rupees value for the acquisition, or the transfer will not be readily available.
But why is that so? Like when I go to the, the exchanges also, I'm exchanging my Bitcoins for a certain value against another value of Bitcoins, right? So I already have a value set out there. So where is the difficulty in determining the value coming into?
The cost of acquisition.
That
Explain it in simpler terms. Sorry.
Yeah.
Sarna. Tell me something. You bought, let's say, a cryptocurrency at 100 rupees.
Yes, Your
Okay.
Lordship.
Now it has gone to 1,000 rupees. Because the
Yes.
price is increased. Now, do they tax you at 100 rupees or they tax you at 1,000 rupees? Or they tax you right at the time of acquisition or at the time of selling? How does the section function?
At the time of selling, whatever the profit is earned, the 30% will upon the profit.
So what is wrong in that? You are earning out of it, irrespective of where it is coming from. You are making a profit out of it. They're charging you 30%.
Yes, there is a one again condition that the no set up and carry forward of the losses. I will come to that
Sorry,
point.
can you repeat? Can you repeat? Sorry.
There is also one condition again, which is no set off or the carry forward of losses. So I will come to that point also.
Okay. So how do you explain that to me? Set off. How do you set off? So basically, you bought, let's say, two different tokens, two different cryptos, one for 100, one for 100 again. One made a profit of 1,000, the another did not make any profit at all, or went for 50 rupees. So you plan on, setting off the losses of this crypto with the other crypto.
No, Your Lordship. I will explain with illustration. With my
Please continue.
if you permit.
Okay, continue.
So, income tax.
Sharnya, was your query answered?
Yeah.
I'm sorry.
No, that's okay.
Okay, continue.
If A is a person, if A sells an NFT of a artwork for loss of rupees 10,000 and then sells a unit of Ethereum, which is crypto, for a profit of Indian rupees 50,000. A would be liable to tax on the entire profit of Indian rupees 50,000 from the sale of Ethereum, but would not be able to set up the loss of rupees Indian 10,000, which is incurred on the NFT. So essentially, under the Income Tax Act, the income from the VDAs are taxable, but not relief in provided in the event losses are incurred. And to that extent, the VDAs are taxed differently than most other assets in India.
So how does it matter?
So in the regular,
it's a good thing that they did. You're making profit out of it. You pay taxes. They can't set off. There's no framework for it. And because I believe the government fails to understand what NFT is, That is why there's no framework for it. So you're making profit somewhere, you pay the tax. Why set off there? There are separate things, no?
But in the Indian equity market, when we such an incurred loss, there is a provision of set off. So we can.
But you are not in equity market. Are you in equity market?
Yes, Your Lordship, we are not in equity market.
Continue. You have 3 minutes. Finish off your submission.
And the question arises whether the trading Bitcoins virtual digital assets will be a business income, and if it is a business income, whether it should be covered under the head of income from business and profession. Since the VDA is not a capital asset, it may not be covered under the head of capital gain, but being an asset of a trading of such an asset should be covered under the income from business and profession. And if so, that all the expenses incurred for earning the income should also be allowed rather than restricting it to the cost of acquisition of the VDA. The classification test has a component of a non-arbitrariness that permits the assessment of a state action to make sure that it's non-arbitrary from the purpose of a view of equality. The talk on the selection between the old doctrine of a reasonable classification and therefore the new doctrine of a non-arbitrariness overlooks the very fact that the normal equality test of a component of a non-arbitrariness and interpretation of Article 14, which deals with the many conceptual concerns in understanding and interpreting the relevance of a
Counsel, sorry
non-arbitrariness.
to interject here. I think your second, your Council 2 is dealing with the constitutional part of it, I'm guessing.
Yeah, I will just end up with this.
Okay, because I think the time is 3 minutes and also.
Yeah, I will sum up in the 3 minutes. And
oh, okay.
And again, coming to the Article 265 of the Constitution of the Parliament says that the no tax shall be levied or collected except by the authority of the law. It means the taxation is an essential feature of the government of Parliament and it cannot be determined on the basis of assumptions. So with your Lordship permissions, my co-counsel will be dealing with the
Yes,
second.
fast.
Warm greetings to your Lordship. This is Council 2. With your Ladyship's permission, may I collectively address the bench as your Lordship?
Yes,
Anything,
please.
as long as
Anything will do.
Much obliged. Your Lordship, my arguments will be in 3 stances. Firstly, I'll be dealing with the digital assets and secondly, how the section is violative of Constitution of Parliament, and lastly, Article 265 of the Constitution.
Council,
If it's,
only the last 2 arguments, okay, because we already have a detail on the digital assets.
The one which I am
relevant for your arguments.
Yes, Lordship. I'll start with the section and directly I'll jump into the article then.
please.
Yes. So the issue in hand is whether or not Section 115 BDH of Income Tax Act is violative of Constitution of Parliament. Your Lordship, the section reads as where the total income of an assignee includes any income from the transfer of any virtual digital asset, the income tax payable shall be aggregate of below to it the amount of income tax calculated on the income from transfer of such virtual digital asset at the rate of 30%. So this is not only saying which is saying 30%. So your Lordship, here while gaining such a tax at the rate of 30% without having any justification for it is violative of Constitution of India, Parliament. So Article 265, which reads as without the authority of law. So which means no taxes can be collected is what this article means in simple terms. So when there in the state of Parliament, when such pandemic is going on, when the entire, not only Parliament, when the entire world is behind this pandemic and citizens of the state are trying to gain not only for not only for their upliftment, but also for the upliftment of their economy. At such a time when citizens are buying some digital currencies, digital assets, the tax which is applied on them is 30%. When
Are
on
you
other,
really bringing, Council? Are you really bringing the pandemic to it?
I'm sorry, Your Lordship.
How is the pandemic relevant here? There are
Because
10,000 ways of making money and saving your money. How is pandemic relevant?
Your Lordship, how pandemic is
Investing in something which is not regulated, which has no control over how the currency will function. There's no government regulation which protects you. Why do you take that as a defense? Out of all the defenses you had.
actually, Your Lordship.
Continue.
Yes, Your Lordship. So, as far as this judgment of this court, which says, which reads as Internet and Mobile Association of India versus Reserve Bank of India, in which it is held that virtual currency can have a unidirectional or bidirectional flow, depend upon the scheme with which the entities come up. Therefore, different types of virtual currencies require different treatments. So here, today, we are not only having one digital asset, but also there are other digital currencies, NFTs, but still the section reads, section 115 BVH of this act only applies on virtual digital currencies, and that too at the rate of 30% interest, where it is not specifying whether the currency which is legalized or not, whether the currency is regulated or not. Directly without any regulation, there is tax gained from the citizens. So this is violative of Constitution of Parlamento.
But Council, Income Tax Act generally deals with the taxation aspect of any asset, right? Whether it is legalized or not, how is that? How is it that the objective of Income Tax Act?
To add on to this, the judgment which you just referred only said that it is not illegal. It did not really legalize cryptos. So
Yes, totally agree.
So I don't see how high tax rates or excessive tax rates is something that we should entertain before us. Just because the taxes side does not make a challenge fruitful here. The legislative intent is something that comes later.
Yes, I'll satisfy your lordships on this. The second judgment of this court itself, which is A.V. Fernandez versus State of Kerala, which says that no tax can be imposed by inference or by analogy or by trying to probe into intentions of the legislature and by considering that what was the subject matter. So, your lordships, if the legalization or of the digital asset which is not yet made, and still there is an act which is applying 30% of tax, which has no any fundamental foundation, and gaining tax without justifying it is unconstitutional.
You can't end every paragraph of yours with it's unconstitutional.
I'm sorry, your lordship.
And also, counsel too, this is a 1957 case, right? Like, is there no current case? I think income tax regime has been, taxation regime has been quite huge in the past years, right? I'm sure there are cases where this point was argued. I mean, after 1957, law, technology, the world has changed. So
yes, but
I'm not.
Yeah,
go ahead with the arguments.
Yes, my submission, my intention behind taking this judgment was how can the legislature make such a act where the fundamental question.
What was the facts of the case of that case?
The facts of the case, I'd like to invite your lordship's attention to the compendium which has been sent.
Just give us the fact.
just give us the fact, like how is it different from our
we
case?
don't-
How is it similar to our case? We just want to understand the similarity and the authority.
Yes, yes. Your lordship, as far as the facts of this case are concerned, where uh, such an tax which was not in the first place to be taken by from the citizens was taken by the concerned authority, and therefore this specific judgment was passed. So in today's case, XYZ versus the Union of Parlamento, here also, your lordships, where the taxes are increased, which in short, the currencies which are not legalized, the act has been made and they are gaining tax out of it. Therefore, the judgment clearly applies to this
Are
case.
there any judgments which support your case, which say that if a certain act or a business is not legal, then you can't, has not been legalized or is legal, you can't tax it? Is there a judgment which says something like this?
Yes, I do have two judgment on it. One
What
of
are the
which
judgments?
may I read the judgment?
You just need to give us the facts of the judgment, the name, the
Yes,
citation.
definitely, your
Please,
lordship.
please, go ahead.
So the facts of the judgment, which was held in Lord Krishna Sugar Mills versus Union of India, your lordship, sugar merchants had to meet some export targets in a promotion scheme started by the government. But if they fell short of targets, then an additional excise duty was to be leveled to the shortfall. This court intervened here and said that the government had no authority of law to collect this additional excess tax. What this means, in effect, that the government on its own cannot levy this tax by itself because the parliament has not passed it, because earlier it has not legalized it, unless and until the things which they are going to, the whole motto of the judgment, your lordship, is when you are taxing something, whatever the rate of interest may be, what justification are you giving behind it? That what plays an important role.
So
Merely,
isn't the justification given that even though it's not legal, the reason why the authorities are doing it is to get a grab on how much crypto is being traded in India? Because nobody knows who's trading, what amount are being traded, all of that is not known. So isn't the idea behind taxing is to know how much is being traded, who's trading, who all are trading, who are involved? Isn't that the case?
exactly, your lordship, that what my point is. There is no any authority, there is no awareness, there are no any names, there is no authority, and still we all know it is decentralized. The authority also knows, everyone knows, but still there is no anything legalized, regularized act on this, rules made on this, and just for the sake of gaining tax, this is happening.
Understood.
Your
Continue.
lordship, it is crystal clear, it is well said fact that it is decentralized. So there is huge risk involved in it, not only of some of the citizens, but also of the entire world, your lordship. When such regulations has to be made, when such conventions by the UN has been made,
What conventions of UN are you talking about?
your lordship, it is not in my memorial, but this is my submission, oral submission.
You can't make submissions beyond your memorial.
If your lordship permits, just one point which will make relevance to this.
How do I know it's a verified point if it's not in your memorial?
With your permission,
I can make up a
my
UN convention
respondents,
saying that
my
Indian
respondents may
democracy.
take, your lordship, my respondents may take objection on this.
Continue.
Yes, my lordship, only one point to make out of it. It is only that when the regulations has been made by the UN.
What regulations have been made by the UN?
I'm sorry, your lordship.
What regulations have been made by the UN?
Yes. The regulations regarding this digital currency, how we have to implement, how we have to regulate. But still, there is no any regulation or implementation or the execution of such has been happened in the country.
I am on Google right now. I can't find any such a regulation which you just claimed. In fact, the
I'll,
first news which comes up is UN trade body calls for halting cryptocurrency rise.
Your Lordship, there is one regulation.
And are we bound by some treaty by the UN?
Not at all. We are bound because that altogether is an international law, which is a weak law. So
I would suggest not arguing this point. This will go against you.
Yeah.
Back out right now because it's not adding up. Thanks to virtual, we are on laptops right now as well. So it's helping that this point is not adding up at all.
all right, Your Lordship. If my worthy respondent takes objection, I have points to
No,
present on that.
the bench is objecting to it.
All right. So if Your Lordship,
Move on. Huh?
yes,
Please
yes,
continue.
Your Lordship. If Lordship is satisfied with issues in hand, may I proceed with the prayer?
You're telling me about this another judgment which you had, which says that when things are not legal, they cannot be taxed. You refer to one judgment, the Krishna Mills, I think. The second, what is the second judgment?
Second judgment, I would like to point at the time of rebuttals, if Your Lordship permits so. Otherwise, I can place it right now also.
Please place it right now.
Yeah, place it.
Yes. So the judgment says that Tangful versus Simirai Shalai, all the villagers were paying.
Which year is it? What is the citation?
The citation, Your Lordship, I'll just. Yes, it is of this court in the year,
Which year?
1950. Just
What
this much.
what illegal act was taxed as per this judgment?
Yes, yes. So Article 265 was raised in this case, where the villagers were paying an amount of ₹50 per day to the headman in the place of a custom to render free day labor. This was done every year, and the practice had been continuing for generations. The court in this case, held that the amount of ₹50 was like collection of tax, and no law has authorized it, and therefore violated Article 265. So unless and until there is
how is that connected? How is that connected to your case?
Yes, how is
that is
connected?
By the. So let me get this: the village sarpanch was collecting 50 rupees from the villagers.
Yes, you may say it.
So village, you can't compare village sarpanch to the legislative body.
Your Lordship, definitely not. But the relevance, the connection of this is nothing but unless and until there is authority, there is regulation.
What is the ratio? What is the ratio of this case?
So ratio, Your Lordship, so Article 265 is infringed every time the law does not authorize the tax imposed unless and until there is some regulation.
Just read up the ratio of the case.
That what? Yes, Your Lordship. I'll read the ratio. Article 265 has to be in when Article 265 is in question, and where the tax which is imposed has no made any authorized collection of it, and which is violative of Article 265, which is infringed. So the law does not authorize the tax which is imposed. So, Your Lordship, I'd like to invite your attention.
Shouldn't you be then arguing that the authority did not have the authority to create such a section, create such an amendment? We are talking about the authority, right? The Article 265 reads that Indian deals with the taxes not to be imposed save by the authority of law. Shouldn't the first question be that they have no authority to create such a section? Under what authority have they made this amendment?
This 115 BBH, which you're talking about. Yes, earlier the section was 115 BBG. Yes. After this section, this 115 BBH was inserted.
Okay.
If I'm not wrong, from the first day of April 2023, it will come.
Did they have the power? Did they have the power to make this amendment?
Yes, Your Lordship, surely.
If they had the power, then how is it unreasonable?
If they have the power, then what is the issue? Is it the question?
Yeah. What is
Your
the issue?
Lordship, because yes,
They
Your
have the
Lordship.
power. We do not challenge. We do not bother with the policy decisions of the government. That is their part. So if they have the authority to create such a section, to impose a tax on you, so till now you have not been able to say that why they can't tax on something which has not been legal. It's something which is not legal. Now,
Yes, Your Lordship. I'll I'll accept. I'll make the statement that the respondent, the authority, the income tax authority, the government can. The only role is to play is that to collect tax. However, you get the income. Whether you sell drugs, whatever you do, the key role is to just to get the tax out of it. But
are
the
you comparing crypto to drugs?
no. I'm just making the submission for more clarity. So let us take whatever, because it is decentralized. We don't know which authority is running all these cryptocurrencies. Just because we have blockchain, few governments are making that we are not even legalizing, or we are not uh, illegalizing these currencies. So my point making behind this is, if not only one digital asset, Your Lordship, in today's case, the issue pops up of digital assets, NFTs, etc. But the section speaks only about virtual digital assets. How come one thing which is not clear by the makers of this act and gaining tax from all other ways out of this? Because there are varieties of
Exactly. There are varieties which the tax authorities, which the legislative, they don't know like what it could be. So having a broader definition makes more relevant in this case.
yes, Your Lordship, but as far as the interpretation of such statutes is concerned,
I am not bothered with interpretation. The
Yeah, I'm
authority is not bothered with interpretation.
Your Lordship, Your Lordship, if you may permit, I'll like to make the submission that such virtual digital assets, which is an issue, or in the section itself, it is not a broader class, because NFTs doesn't come into this category itself.
where
There are,
how do you say that the NFTs don't come to this category? We don't
yes,
even have a categorization currently, right? So
yes, there is nothing on this, Your Lordship. There is nothing on this. There is no.
council, we both are saying the same thing. Okay. However, the differentiating point here is you have to prove me how it is unconstitutional. Having this is unconstitutional or violative of the constitution. So that is still an argument which is pending. I mean,
I'll make this
that
last.
is quite a well, I would tell. But
I'll try to answer your question.
I think your time.
My time is already over. Yes.
Yeah, so I'll just give you 1 minute to wrap up.
1 minute time. Yes. Yes.
Not
Your
much.
Lordship. Yes, Your Lordship. I'd like to quote Edgar's statement. Justice may be blind, but it has sophisticated devices to hear. So the reason behind making this quote was only one thing, where the other assets, not only the digital but other assets, are taxed at a lower interest. And for the promotion of such digital currencies, the government should uplift the citizens by taxing it less. It will be more of doing the business and gaining the economy, but it has not happened. If we take the example of stocks, which at the long term they are charging 10%, and for the short term is 15%. But here directly 30%, when entire world is behind to get currencies and to uplift their economy and to gain more profit out of it, where the government should uplift, but it is not doing so.
30% is a decent amount to tax, right? I mean,
not at all, Your Lordship. The government.
Hear me out. What I'm trying to say is, what is the ratio of taxation what I am giving is mine. First of all, what is the, I mean, what amount of population uses cryptocurrency right now? Shares, I get it. Shares everyone uses, but what is the grassroots level of reaching of cryptocurrency? Have you checked that? Have councils checked that? To understand the reasonability of the income tax authorities taxing it at 30%. Aren't we taxing the cream level, which is kind of beneficial in any way?
Your Lordship, if I give the practical example of my life, my next friend or my neighbor or the colony beside me or the slum, every single person today have a smartphone. And even if not a smartphone, one of the vendor in some native place in Bihar was asking for cryptocurrency instead of the currency which we are using today.
One-off cases, council. I'm not disputing those. Those are one-off cases, and my mate doesn't have a smartphone. So, I mean, I don't understand the relevance of first the code. Second, I mean, coming to this part. So, I gave you one.
Okay.
If you still have any further questions, I mean,
Your Lordships, would like
just
to
summarize, council.
Yes,
Please
yes, I
go
would present the prayers. Wherefore, in lights of the measures at issue, legal pleadings, reasons given, and authorities cited, the petitioner respectfully submits before this Honorable Supreme Court of Parliament to and further praise for the court to the writ petition be allowed. The said section imposing tax on digital currency at the rate of 30% be declared unconstitutional and be quashed and set aside. Much obliged.
Thank you. Yeah, please, respondents.
Moving on, the respondents, could you specify your time breakup, please?
Yes. So the first speaker will be taking 10 minutes and the second speaker will be taking 15 minutes for the issue and 5 minutes will be reserved for the rebuttals. Rebuttals. May I start?
Yes, please.
A pleasant afternoon to your lordship, your ladyship. I, Aditi Shukla, along with my co-counsel Vinayak Tiwari, take eminent honor to present this case before the Honorable Court and would be representing the respondent, the Republic of Parliament. I will be arguing on the first issue as specified earlier for 10 minutes and my co-counsel will be arguing for 15 minutes and we reserve 5 minutes for the surrebuttals. If your lordships are familiar with the facts of the case and the factual matrix, the council would like to proceed further with the first set of arguments if your lordship permits.
Yes, please. Continue.
Much obliged, your lordship. Your lordship, it has been established in the arguments that my arguments will be taking a part in two particular limbs, one of which will be the argument established on how the government is justified in taxing VDAs and how the pertinent provision has taken place. It is humbly submitted before the Honorable Supreme Court of Republic of Parlamento that in recent years, the use of VDAs has gained surmountable increment, which on the flip side has served as a safe haven for illegitimate activities such as tax evasion, finance frauds, terrorist activities, bribes, money launderings, and this presents a challenge to the tax enforcement and agencies. On the root cause of it, here we understand that the mechanism that the VDAs provide has a loophole due to which a lot of tax evasion can occur in many different ways. As stated by Subhash Chandra Garg Committee, constituted by Department of Economics Affairs, Ministry of Finance, I would like to quote, VDAs lack intrinsic value and are subjected to fluctuations. They are decentralized networks with no central authority, transactions are irreversible, and they provide a degree of pseudonymity, which creates protection issues, and these risks are for financial system and overall economy and can facilitate criminal activities. Your lordship, in the precious time of this era, we have to understand that the previous tax regime, which was executed by the government, there was no uniformity in the virtual digital asset and transactions, and in many cases they were not reported at all. So, for instance, there were circumstances where two transactions were occurring, and there was swap of two different virtual digital assets in virtual medium. And when this took place, the transactions were not registered at all, which means no tax was levied. Due to the aforementioned circumstances, Your Lordship, this non-taxability of the income from such transactions was occurring on such a huge level, where on the first hand, the advancement was leading to a loss of revenue to the public exchequer. Your Lordship, in order to counter all these dilemmas, the government has introduced the new taxation. Your Lordship, I would like to draw your attention to page 9, issue 1, para 4 of the memorial. If Your Lordship is with me. If Your
Yeah.
Lordships
Yes,
are
I'm
with me.
with you. Let me just take out your memo.
Yes, Your Lordship.
Just like page 9, you're saying?
Yes, Your Lordship.
Okay, yes, continue.
In the page 9, para 4, we discuss that when the pertinent issue of taxing VDAs comes into question, it is to be noted that in case of CIT versus K. Thangamai, it was held that in income, if it is earned in any manner, it will be taxable. And it was noted that there is nothing like an illegal income so far as tax collection is concerned. Your Lordship, it was held in the case of Commissioner of Income Tax versus P.R.A. Singh by this apex court only that the previous judgment stands with endorsement, and if a business is illegal, the profits or the losses will not be enforceable by the law, but the issue does not take the profit out of taxing statute. Your Lordship, it was also upheld in the case of Commissioner of Income Tax versus S.C. Kothari that once it is found that there is business, legal or illegal, the income tax and the laws say that in pertinence to the law, I mean the section 28 of Income Tax Act, that the profits of the business shall be chargeable. And these profits shall be chargeable to the tax, and thus both the incomes are taxable alike. So, Your Lordship, the bench would like to proceed, the council would like to proceed with the argument that this settles down the failure of the argument presented by the petitioner, and that the government is justified in its initiatives, and hence
But council,
the
tell me
measure
something.
is. Yes, Your
Council,
Lordship.
tell me something. You have no regularizing body for cryptos, for VDAs. There's no way of knowing who's investing, how much they're investing, who's creating losses, who's creating profits. In that scenario, how do you expect to charge these taxes? Let's say we have a few Indian traders or brokers in between, which help you medium portals to buy crypto. But if somebody is trading from outside of India, how do you generally catch someone who's trading? If you have no you literally forgot to create a body to regularize it. And in the meantime, you're only taxing it. That's for literally the lower strata of the society. Somebody who's not tech savvy to that extent or who cannot deal in the dark web with regards to crypto. So you're literally only 5 to 10% of the people who are genuinely trading in India are the only ones who will be paying taxes. By using this tax, you're creating a bigger gray economy than there already was. And tell me how exactly does this tax solve the issue of frauds or let's say money laundering being done through crypto? A tax does not. How will you catch those culprits? You've not created a body. You simply tax it to make sure that some people don't invest in crypto. But in that case, the amount is too high. You either make it completely illegal or you make it legal.
Your Lordship.
Hmm.
The pertinent question. The respondent would like to proceed with the fact that this is a new system, and this system was provided for a future step so that a ground can be made for a future regulations. Your Lordship, regulation of cryptocurrency is very difficult in the pertinence of today's laws because there are a lot of confusions and chaos. There is no accountability and there is volatility. And also because of the previous facts that I stated, the pseudonymity is also there, due to which cryptocurrency and virtual digital assets and other umbrella bodies of the similar format are hard to track. For this particular tax regime is introduced, where if a transaction is made, as per that transaction, if there is income or capital gains in that particular aspect, 30% tax will be levied, and a TDS of 1% will also be deducted, so that we are able to track the transactions that are occurring in the economy. I agree that right now the economy is in a gray state, and the regulatory framework is not present particularly, but the government is still working in this, and the government is also asking for different suggestions, putting out bodies, bills, and discussing how and in what manner VDA should be implemented in the economy, and how it should be legalized or in any aspect worked upon, so that with the passage of time, we understand how we are going to endorse our digital economy with the virtual digital assets. If the lordships are agreeing with the facts, and if the lordship allows, I would like to proceed with the next set of arguments.
But don't you think, before you start off with the other part of the argument, don't you think you should have created the legal body first and the regulatory body first and then tax? You've done it the other way around. Saying
Your
that we
lordship,
want those. Continue. So I believe that the regulatory body should be there. Or you make it completely illegal, which you tried and failed. So in that case, what remains is that you can only regularize it, and taxes is simply not really regularizing it. Catching that the 10% TDS is still understandable that you make on this transaction, but somebody who has been dealing in crypto for ages and continues exchanging those cryptos through cryptos without really converting that into money, these mediums outside, then you don't really have a track on those things.
indeed, your lordship, and that is why I pointed out earlier also that even earlier this was the provision, and we, as the respondent and as the government's respondent, understand that there is this huge issue that we are dealing with the matter, and we would like to take the suggestions and the advice that is given by the bench for the further arguments, and we will understand that these kind of suggestions can also be taken. But as per the hindrance, when we talk about, the lawmakers understand that there is this hindrance and inability to determine its functioning, because there is no regulatory framework and no particular definition, and the respondents also agree on that fact, and that is why we are still functioning in it, and we are asking for suggestions. We are going for this new system, and we are trying to understand how the digital economy should be established with the help of PDAs. So if your lordship agrees, if your lordship allows, much obliged, your lordship. Your lordship, thus, when the taxability of VDAs is justified and not in question, the council would like to proceed forward with the mechanism that the government is trying to apply in the particular case. In the applicability of the tax, in the case of Ahmed GH Arif versus CWT, the Supreme Court observed that the property in term of the widest and import subject can put out limitation, and it does not merely mean physical property or any property of physical presence, but right, title, or interest. And in the similar manner, by the section 214 of the capital asset of income tax I think
continue.
time is up.
Not an issue. Continue.
Okay, your lordship, much obliged, your lordship. Yes, your lordship. As per that section, we would like to proceed forward with the argument that the VDAs qualify as an intangible capital asset, and hence it can be taxed either under heads of profits and gains or business or profession. And your lordship, with this, it is most respectfully submitted that the law has brought a ground which allows future development of the industry to provide a firm direction in the space of digital economy. And we would like to take forward the suggestions that have been brought up in the discussion also, so that the respondent will take these discussions forward. And with this, if the lordships permit, I would like to proceed forward and put the forum to my co-counsel.
Please go on. Yes.
Much obliged, your lordship.
Your lordship, I shall be presenting before you the arguments pertaining to the issue 2, which is dealing with the fact that whether or not section 115 BBH of the Income Tax Act is violative of the Constitution. Your lordship, before I proceed with my arguments, I would like to tell you the structure that I shall be following. So your lordship,
no need surprises.
Yeah. Okay, sir.
You don't need to give us the structure.
Indeed. Much obliged, your lordship. Lordship, the government of the Republic of Parlamento is sovereign democratic and republic. And the Constitution of the Republic of Parlamento is bestowing the government with the powers and rights to tax. Article 265 is giving the authority to tax when it is legitimating tax when it is done by the authority of law. And further, as far as Article 246 is concerned, it is giving the government a list which is there in the Schedule 7. The list 180, entry 82 allows the government to make taxes to the income of the people. Your Lordship, whenever a legislation is passed in the Parliament, there is a presumption of constitutionality, and it has to be presumed that the presented or the passed legislation is constitutional in itself. Thus, the parts of the legislation, even in the pertaining case, that is 115 BBH, is considered to be constitutional. Your Lordship,
Do you have any case in hand which can substantiate this point of yours?
Your Lordships, as far as the case is concerned, I haven't cited that, but there is a very celebrated case of Your Lordship. There is a very celebrated case. I cannot cite it right now, but it is tried in law. Then the name of the case is basically Shri Ram Krishna Dalmia versus the Justice S.R. Tendulkar. It is dealing with the presumption of constitutionality of a particular legislation that is being passed.
Which is what?
The presumption of constitutionality. Your Lordship, if a particular legislation is being passed, it is considered to be constitutional until and unless it is challenged on the grounds of the violation of fundamental rights, which here the petitioners are failing.
So this
Your
was
Lordship,
That is for us to decide, no?
indeed, Your Lordship.
Okay,
Indeed,
and
indeed.
the reason why we are here is to decide on the constitutionality of this. So let's not make presumptions right now. Let's go ahead with something more concrete in that matter.
Definitely, Your Lordship. Your Lordship, it is tried in law that mere rate of tax, the method of taxation cannot be challenged before the court. And it is not upon the courts to decide and embark upon it, because it is a policy matter, which is, as far as the separation of powers is concerned, is a total matter of the legislative bodies, which is the government. Your Lordship, a democratic government is making law, keeping in mind what is good for the people and their interests. And thus, considering the present nature and the present situation and the status of the virtual digital assets, the government thinks that a cautionary approach can be taken by taxing them at 30%, which is for the benefit of people. Your Lordship, the VDAs or the virtual digital assets, they are posing multiple questions, which cannot be answered at this instance, considering that they are not centralized, they are not regularized, the transactions may be anonymous, the transaction may not be traced. If Your Lordship may refer to para number 3 at page 11, they may find that the union government is in the process of making it stand clear on the virtual digital assets. And as my co-counsel already mentioned, the government is also open for the suggestions. The government
So
is
should we keep this matter pending till the regulatory framework is there? Should we put a stay on the interest rates till the regulatory framework is existing?
definitely not, Your Lordship, considering that putting a stay on the interest will hamper the nation, considering that the legality or the illegality of the VDAs is not the matter when we consider about the taxability, which has been proven by my co-counsel. If Your Lordship is satisfied, I may continue.
Continue.
Much obliged, Your Lordship. Your Lordship, as far as the reports are considered on the cryptocurrencies, which has been cited in page number at para number 3, the government is taking a cautionary approach, and thus, for the time being, they are taxing it at 30%. Reforms may be expected in the future when the stance of the government is clear. Your Lordship, thus a tax of,
Sorry, Council, if the stand of government is not clear, taxing it at 30%, isn't that unreasonable then?
Your Lordship, as far as taxing at the 30% rate is considered, Your Lordship, it is doing a two-way, it is having a two-way purpose. First, taxing at 30% will make sure that there is a good amount of revenue which is generated. And second, it is also doing a first-hand screening that only the legitimate players are going there. Considering that
we can do even if I am on like 5 or 10%, right?
Your Lordship, but the thing, Your Lordship, but that won't be having, Your Lordship, such a low rate of taxation as far as the nature of the cryptocurrencies or the VDS is concerned cannot be applied to it, considering that we have to be very cautious. If we are applying,
Council, what is the rate of tax on shares?
Your Lordship, it is 10% for the long term and 15 for the 10% for the long term and 15 for the short.
Why can't
And
we
what
have?
is what is it on assets?
Your Lordship, the council would plead ignorance for the fact.
Should not, capital gains is 20%, but okay, this is for your knowledge. And
Much
so
obviously.
why should it not be in these two categories?
Your Lordship, because there is an intelligible differentia which is followed by a rational nexus, which is making the virtual digital assets a distinct class altogether, and hence there cannot be they cannot be treated at equity with all the other incomes.
For that, you need to define what a VDA is. You have not done that. There is no regulatory body to define it. You have already made a distinct class of its own, and you have taxed it, but there's nothing which defines it, that this is what it is, and this is what you pay taxes upon. On your whims and fancies, we have put a 30% tax bracket on it, killing the international cryptocurrency market in its entirety for that time being.
Your Lordship,
So
if
you
that
have to
fact is
consider.
considered, I would like to show that there is a difference between the income sources, and thus it cannot be taxed at par with the legal income sources. Your
Please,
Lordship, as far
please focus on this point and tell us how it is.
indeed, Your Lordship.
Where is
So,
this
Your
in your
Lordship,
memo that there are different types of income sources?
Your Lordship, if you may refer to para number 5, there I have done
Of page number?
Of page number 11, Your Lordship. Your Lordship, the distinct classes that I have that the councils are considering is the one which are legalized and recognized by the government, and the others which are not. And thus a 30% tax is put on it. If we take the differences, then one income source is if we consider, let's say, the share market, for instance, it is legal, it is certain, it is centralized, it is regulated, it is accepted, and it is traceable basically. But as far as the VDs are considered, so all of these aspects of share market cannot be dealt with or cannot be seen in the VDS, and thus it cannot be given an equal treatment. And as far as the equal treatment rate of taxation and the method of taxation is concerned, it is a total policy matter of the government, which is done by deliberation. And until and unless it is not infringing upon any fundamental right, it cannot be questioned in a court of law. Your Lordship, as far as
Council, I understand that, I can't keep it in the same basket. But what is the harm in having the same rate of interest here?
Indeed, Your Lordship, I shall be deliberating upon it. Your Lordship, as far as the same rate is considered, it cannot be levied upon it. The reason being, the 30% tax is a high rate, and it can also work as a first screening to the legitimate use of it, considering that people will not be using it casually, and people will be having a serious deliberation upon before using it, considering that you have to pay a 30% of tax, which is a big chunk. And in the time being, when the government is making it stand clear, government might be coming with a regulatory framework, there can be reforms which can be expected in it. And I think for the time being, the petitioners must cooperate with the government. If Lordships are satisfied, we may move forward with the other set of arguments.
Yes, please.
So, Your Lordship, as far as the para 5 was considered, I have drawn a difference between the legitimate source and a source which is not yet legitimate, and thus there is an intelligible differentia which is followed by a rational nexus, and thus not the equal treatment. Your Lordship, as far as the fundamental rights are considered, so if it is failing this test, it is not violative of Article 14, and thus it cannot be held that it is liable to be struck down. Your Lordship, the other fundamental right in question, which is partially can be 19, considering that the petitioners are also having a point of view that it might be hampering trade or commerce. Your Lordship, as far as the case of Internet and Mobile Association versus RBI is considered. In that particular matter, one of the contentions that was raised by the petitioner was that it will be the restrictions on the crypto by RBI will be hampering Article 19 and Article 19(1)(g) of the petitioners. Your Lordship, if you may refer to para number 9 of page 12, you may find the citation wherein it was held that if the people are using crypto as a hobby or casually using it, they cannot get a relief under Article 19(1)(g). And even if they are using it as a business or a trading, they still cannot use Article 19(1)(g), considering that at that time, when the regulations were, when the restrictions were being made, it was not hampering the business in totality. And this is only a taxation method. This is not a restrictive taxation. And thus, it is not hampering the trade in totality. And thus, it is not violation of Article 19 and not liable to be struck down. Your Lordship, the last leg of my argument deals with the non-violation of the fundamental rights. If Your Lordship may refer to para 6.
Did you not just covered it?
Your Lordship, I have covered it though, but here I shall be dealing with the right usage of the writ. Considering that a writ cannot be a means to indicate policy preferences, what rate has to be taxed and how it has to be taxed. And thus, the petition is devoid of any merits. There is no violation of fundamental rights. They are questioning the legitimacy of the government in taxation. And thus, it is humbly prayed and most respectfully prayed before this honorable court that the petition might not be allowed and quashed at the first instance. If Your Lordship is not having any further question, I shall be moving forward with my prayers.
So, Sharanya, do you have any questions?
I don't have any questions for now.
We're good to go.
Wherefore, in the light of the issue raised, argument advanced,
Prayer is
authorities
not required.
cited,
It's okay.
and reasons given.
Prayer is
Lordship?
not required. We know your prayer. It's okay.
Much obliged, Your Lordship.
Okay. Rebuttal round. Petitioners,
Yes, Your Lordship.
do you guys have any judgments which say that such high taxes are unconstitutional?
Your Lordship, I would like to counter on few points. As of now,
It's
yes.
better if you can answer this. Do you have any judgments in the previous past of this court which is held that high taxes are unconstitutional?
Yes, Your Lordship. In the case of,
Is it in your memo?
yes, it's in there, my memo. Deputy Commissioner of Income Tax versus Pepsi Foods Limited.
Okay. Page number?
It's on page number 12, last
Page number
paragraph.
12.
Last
Okay.
paragraph.
Hmm. Which judgment is this? Page number? I'm on page number 12.
Yes, it's in the footnotes, Your Lordship. If you could see, it's
Yes.
numbered as 9. So in this judgment, Your Lordship,
Second last sentence.
Got it. Okay, can you give me the ratio of the judgment, please?
yes, Your Lordship. So actually, in this case, there was excess of tax which was imposed on the company, which was not legal. Therefore,
Which tax are we talking about? Which tax was imposed on the company?
income tax, Your Lordship, the income tax.
So, are you claiming income tax to be illegal?
No, I'm not claiming it to be illegal at all.
Okay.
And
I
in
am-
the first
yeah.
instance, prima facie
What
also, I have never-
what was the percentage of tax levied on them?
it was somewhere around 25% upon the tax which was already charged on the company.
Okay.
So for making such transactions, for more trade and commerce, for gaining the benefit for the company and for their development, okay, just because of few more these things, the authority made that this company has to be has to give more of 25% of tax, which was not
Okay.
legal. just because under the caption of section Article 265, these authorities are keeping on asking for taxes.
Got it. Understood.
Yes, Your Lordship. So
Okay, now
may
come
I
to your
read?
4 points. Yes.
Yes, Your Lordship. As far as my worthy learned opponents, very nicely and fancily the argument which were presented, but the issue 1 and issue 2, the only one question which has to be taken into focus, firstly the justification, and secondly the violation of the constitution.
Yes.
Speaker 1 of opponent, my learned opponent, has truly and specifically mentioned there are difficulties and there is chaos, there is pseudomity, there is no such anything with us, and still they are still the authority is taxing at the rate of 30%. Also upon that, they have made a statement in their arguments that they are accepting the suggestions. Your Lordship, this all work is of the background when before making such act. Also, they are trying to say, also they said that they're trying to apply some of or other mechanism. Also, they have mentioned intangible assets in one of their judgment, which has no relevance of this today's case at all, Your Lordship. As far as speaker 2 of my worthy opponent is concerned, he has made the statement that the government allows the government to gain the taxes. We are aware about it. The state government, the state list or the central list or the concurrent list gives them power to gain the taxes. Also, but there has to be some reasonability behind it. Just because you are gaining the tax, none of the speaker have made a justification or the reasonability why are we gaining 30% of tax. Just beating around the bush is not going to answer the question. Also it has been mentioned that cautionary actions, it is for the benefit for the which is fitting for the citizens. This argument has been made, Your Lordship. How it can be beneficial when you are taxing at the rate of 30%? Also 30%, why have they charged for gaining revenue?
Sorry, counsel, to interject here. If we have reasonable, relevant points for rebuttals, then let's take it up. Let's not dissect each of those arguments. Okay?
All right, this last two lines, and I would conclude.
Please summarize your rebuttals.
Yes, Your Lordship.
Summarize as in summarize, like one line.
So there is no any reasonability, there is no justification, and it is violative of constitution. And my worthy opponents have not placed, have not justified while taxing at the rate of 30%. Much obliged.
Counsels for respondent.
Your Lordships, I shall be presenting the rebuttals to the rebuttals by my worthy opponent. Your Lordship, as far as the higher taxation case law that was cited, so that pertains to the double taxation, which won't be having any applicability in our present case, considering that in that case, a tax was levied over a tax. But here it amounts to the first instance of tax. Thus, such a case law is not applicable here. As far as the point of accepting the suggestions from the people are concerned, so that is the work of a welfare government. And thus, being a welfare government, we are doing the job in the interests of people, thus taking their suggestions. As far as the argument rebuttal regarding the intangible assets are considered, so crypto per se is intangible, and thus it is an intangible asset after all. As far as the reasonability criteria was considered, so government is very reasonable in its approach, and it was proven by me by giving a test of intelligible differentia followed by a rational nexus. As far as the legitimate authority of the government was challenged, so the government is gaining all the legitimate authority from the constitution. It was said that the constitution is being violated, but none of the right articles were cited. It is a policy matter which is the right, the sovereign right of the government to deal with. And thus, it is not having any question in the court of law as far as the rate of the taxation and the method of the taxation is concerned. On that note, Your Lordship, I would like you to quash the petition because it is devoid of any merits.
Noted.
Much
Thank you.
obliged.
Thank you, teams. I think, Court Master, we can ask the teams to leave and we can have a sitting. Is the Court Master
Bef-
there?
Before we conclude the session, on behalf of Advocate Manav Thomas, sir, I request the judges to send the score sheets back via email, and
I'll do
please give feedback to our speakers to help them improve in the further rounds.
Okay. Sharanya, would you like to start?
On the feedback? Okay.
Yes,
Okay.
please.
I'll start with the first team, Council 1. Sorry, I can't see Council 1 anymore.
You have to
Yeah.
scroll down, I guess.
Yeah, hi. Your arguments were good. I would like you to be, more coherent when you are presenting your facts, when you're presenting your cases. Okay. There were quite a few scenarios where you were reading out your notes and everything. That's fine. That's fine. When you're doing a moot court, it's fine. But excessive reliance is something which will irk off the judges. Okay. So you have to be very careful about it. I think I've mentioned the coherent portion. Okay. Second, council number 2 from the first team. I liked the way you presented. Okay. However, I would suggest not to get so hyper or agitated when, judges ask you questions. Okay. Or when you are answering the questions, it's absolutely fine. Your other thing is your way of making citations. Citations have to be very, very, I'm not saying it has to be absolutely pertinent, but try having, we are in 2022, right? So citing judgments from 90s seems very obsolete in my opinion. Okay, so, but otherwise you guys were very good. Thanks for putting this up. Team 2, Council 1, you were good. Your arguments, your presentations were good. What I felt was missing was that confidence in answering the questions. You were right in whatever you were saying, but I felt like there was sort of a distrust in your mind with respect to those answers, which shouldn't be there. You were good, have that confidence level up. Okay. Second, with respect to your flow of arguments, have a flow in mind. So that wouldn't hamper, whenever you are trying to answer the judge's questions. So that would be fine that way. Otherwise, very good. Good presentation. Council 2 from the second team. Your answering questions was very commendable. That I really liked. So you were fast in answering the questions. I think from all the speakers, you were the most resilient one. Second thing is, again, not to get, super thrown out whenever the judges are asking questions. That is, again, as I just mentioned, it is to throw you out of your league. Otherwise, I think it was all great. Chetan, your bits and pieces now.
Yeah. So I think I'll make a general statement for everyone. I'm assuming that you guys are, been in the law college for at least 2 to 3 years now, because your research is good that way. You guys did an excellent work with the memo. What I'd like to suggest is like real life advice here. Visualize how you plan an argument. Think of what the judge wants to hear. Simple as that. And accordingly answer. Our job in every moot is to confuse you. And I think we did that pretty well with team 1. And team 2, you guys took that well. Coming back, you have to ensure that you remember where you stopped. And if the answer is something which is not good for you, and is something that will end up losing your case, don't agree to it. But come back, remember where you left off, you can start off from there. Keep that in mind always. Because in real life also, judges, the sole aim is for them to confuse you. Whenever this matter actually comes in Supreme Court, I'm literally wondering how they'll start off, because it will take you a month at least for completion of arguments. Secondly, citing, yes, I think rebuttal round, emotions are flying high. That is something that you need to keep a check on. I personally feel this issue is a personal issue with me. I also get really hyped up when it comes to rebuttal, and when you have really good points to undermine the other team, it's a really good, adrenaline high which you get. But you have to keep your emotions in check. Team one, you had really good points for rebuttal, but your emotions came in the way. Remember this.
Yeah.
Okay. One more thing, the judgment which you cite, no, remember the facts and the ratio always. You should never be thinking about, you should firstly cite only what is literally relevant, not for minute things. If it's completely covering a case, remember that. Facts should be in summary in 4 lines. These are the facts. This is how it's applicable. In Sir Rebuttal, I think he came up with a really good point. There is double taxation. It's not relevant to our case. So you have to think of judgments which are literally your case covered, and remember the facts. Because in taxation, it's a very technical subject, right? Taxation could mean 10,000 things. What was taxed? How it was taxed? How much was it taxed? Now there are 4 or 5 questions which you answer. Keep it in your mind. That's good now. And I think your memos are pretty good. I'm happy with the memos. And all the best to everyone. May the best team win. And you guys are all going to go places. Don't worry about that.
Yes. Yes.
Thanks a lot, sir. Thanks a lot.
Thank you
ma'am.
so much. It was an honor to argue before this court.
Abhi to, the matter is over. Manners can go now.
Yeah. This is not a court in session anymore now.
This you keep for the real court. They get really happy.
They do.
Okay, guys. Have fun. Happy weekend. And I think your results will be out sometime. We'll take your time from you now and sit and work on the points. Okay? Thank you, everyone.
Okay, judges, it was an honor to have you all. Now we can end this round here.
Okay. Sarangi, do you want to do this on a personal level?
Yeah, cool. I'll just close
Okay. Okay, I'll give you a call. Thank you, everyone.
it.